Now, the other area of concern this court had was the searches, both of Mr. Soukaneh's vehicle and trunk. Andruski argues that there was no constitutional violation as to his search of the interior of Soukaneh's car because it was a lawful Terry frisk of a car. He further argues that the warrantless search of Soukaneh's trunk was lawful under the automobile exception to the warrant requirement. Officer Andruski claims that his search of the vehicle was legitimate because it was a Terry frisk of the car. However, as the court has pointed out, by the time Officer Andruski initiated his alleged Terry frisk of the car, he had already de facto arrested Mr. Soukaneh, having handcuffed him and placed him in the cruiser. And what about this automobile exception? Under the automobile exception, states may allow the warrantless search of an automobile except for the trunk if the police officer reasonably believes that the vehicle holds evidence of a crime. The U.S. Supreme Court has determined that this exception is not a violation of the Fourth Amendment because drivers have a reduced expectation of privacy and because a vehicle is inherently mobile. Notice that the automobile exception requires the officer to reasonably believe that the vehicle holds evidence of a crime, yet nothing in what Mr. Soukaneh said or did, other than stopping in a bad neighborhood, provided any reason to believe the vehicle held evidence of a crime. Furthermore, the automobile exception specifically excludes the trunk. Not only was there no risk of the vehicle leaving the scene with evidence since the operator and only occupant was cuffed and detained in the officer's cruiser, the officer also detained Mr. Soukaneh for 30 minutes after conducting the search, in which there was plenty of time to call in for a warrant. However, we reject Andruski's contention that either of these searches were justified and that they did not violate clearly established rights. In addition to being necessary for Soukaneh's de facto arrest, probable cause was also needed for the warrantless searches of his car. As discussed above, no probable cause existed. So Officer Andruski had no reasonable suspicion that the car contained evidence and had no probable cause either to arrest Mr. Soukaneh or search his vehicle. The court notes there is another way Officer Andruski's search could be considered constitutional. However, another inquiry for determining the lawfulness of a vehicle search during a traffic stop is whether an officer had a reasonable apprehension of danger which may permit a Terry frisk of the automobile. Now, did Officer Andruski have a reasonable apprehension of danger? Andruski argues that the Supreme Court's holding in Michigan v. Long precludes us from finding that he violated Soukaneh's constitutional rights when he searched the interior of Soukaneh's car because of the known presence of a gun. Yes, there was a gun present. In fact, Mr. Soukaneh told the officer that he legally possessed a firearm, produced his permit to have the firearm, and even told him where it was in the car. But that wasn't good enough for Officer Andruski. However, a straightforward analysis of Long leads us to conclude that this is not correct. The presence of a lawful weapon alone does not automatically make someone suspicious, nor a situation dangerous, such as would justify the Terry frisk of a car. The lawful presence of a firearm alone does not make someone suspicious or dangerous. If that were true, every law enforcement officer would be considered suspicious and dangerous. Considering the actions not only of Officer Andruski, but of his fellow officers, including the sergeant, it is understandable why people are suspicious, not of legal gun owners, but of law enforcement.